Welcome to the ins and outs of probate for genealogists. This is number 7 in a series of 9 videos that have been uploaded to the Brigham Young University Family History Library YouTube channel. This one is called An Example of a Simple Probate File. I might make a comment at the beginning that this probate file may not seem so simple, but in fact, compared to the difficulties that you can find in other probate files, particularly in reading the handwriting or examining the records or finding the records, this was a rather simple probate file. First, we'll do an overview of the file. This particular file came from the Utah probate records from 1851 to 1961, which are hosted on the FamilySearch.org historical record collections. It concerns Caleb Haws, who died on the 20 November of 1871. And it's interesting to see that the last probate document in the case file was filed on the 14th of October 1904, nearly 33 years later. This is the first, this is actually one of the last documents in the probate file. There are 62 pages of documents. The wife's name is misspelled. Her name was Eliza, but it's misspelled in the document. And she was appointed the Administratrix for the estate. And this is the final account and petition for distribution. The rule here is to look for the last document first. The last document filed in a probate action will likely contain a summary of what's happened during the entire probate. This is important in order to navigate the file and understand what ultimately happened with the information in the file. So this is what you need to do, is keep looking. And as I indicated, this particular file contained documents filed over the period of 33 years. So searching through the file, unless it is consolidated by the court in one location, could be a challenge. Now, essentially what happened in this Haws Estate is that he died. His wife was appointed the administrator or administratrix of the estate. Then she died without closing the estate and distributing the property. That required that another administrator be appointed. In this case, it was a son. And then the estate of the husband was merged with the wife's estate. Finally, after 33 years, the estate was distributed and closed. Both Caleb and his wife died intestate. That means they died without a will. The first document in the file is a cover sheet. This is something that you may have a tendency to disregard, thinking it's just a little document that you have to go through. But this is an important document because it tells exactly which court the probate was filed in. In this case, it's the 4th District Court in Utah County in Utah. It also gives the name of the deceased as it appears in the court record. So it may be a little bit different than the name that you have recorded or think that is important. Now, these two facts, it also gives the date. There's a number assigned to the probate. Depending on the practice of the particular court involved with a probate action, that number may be significant or not. In some cases, particularly those more recent cases than this one, the number is actually the way that the cases are filed and the way they keep track of the information of the different files. In this case, they were filed chronologically, and so unless you knew approximately when the person died or when the probate was filed, you may have to make some search. Of course, in this case, the records are digitized and online on the FamilySearch.org website. In some instances, obviously, you would have to go to the actual court records in the courthouse and go through the files. So it's important to note the time frames in this particular case because they are quite a bit longer than most researchers would expect. The first document filed in a intestate succession without a will is a petition for letters of administration. This is a very common way to start a probate file. If there were a will, there would be a petition for the allowance of the probate of the will, or a petition for probate of a will. This is almost the first document after the cover sheet, and it's interesting to note from here that Caleb Haws died in Sheffield, England, but was a resident of Provo. So if you're searching for a death record in the Provo, Utah, in the Utah County, you might have been frustrated because of his death in England. And I might note that the probate record might be the only record of the person's death. This is an intestate case. There's no will. Very commonly in the past, it was a requirement of the court that the administrator, administratrix, I'm going to use the term administrator generally. Most of the gender terms have been dropped by the wayside over the years. But in this case, the court required a bond of the deceased wife. That would not be the practice in the courts, more current court proceedings. It would be, however, in older court probate matters, would have been the way that the courts consistently ruled. That means that the bond was either a cash bond or a surety bond, meaning you had to pledge property or something in order to protect the heirs in the case of a wrongful distribution from the estate. The next document is the order appointing the administratrix or the administrator, and this document gives the married name of the wife, Eliza Ann Haws, and the date of death, and a name of a family member. It also gives the approximate value of the estate, and you can see how someone researching this family would find this information very important and useful. It's also important to note that the order was signed in 1878, more than 7 years after the date of death. In other words, before you would find this probate file, if you started searching from the date of death, you would have to go through 7 years of court records. The next slide shows the order appointing the appraiser. The appraiser obviously could not be a member of or related to the deceased. There would have been a conflict of interest, and perhaps the appraisal would not have been believable. The reason for an appraisal in a probate case is usually connected to the idea of paying taxes. Estate taxes back in those days were much more common than they are today, and they could be as common. They could have been assessed on individual items left in the estate. Today, however, in the United States, there is a unified probate or testamentary exemption, the death exception, and that is usually a very high number in the millions of dollars. Although this can change from year to year as the legislature changes the amount of the estate tax assessment. Best to check with an accountant or an attorney as to the current amount of the unified exemption. The next item is an order appointing the appraiser, and in this particular in the way that probate files and orders within the court go, there is usually a petition and then an order and then a notice, or a notice and a petition and an order, and in any case there is always some kind of notice given to the heirs about the proceedings that are going on in the court. And here's the notice for the application, and So the pattern is petition, notice of the hearing. The hearing is held, there's an order, and then there's a notice of the order. In this case, it appears that the reason this probate was opened after the deceased had died so many years earlier was because there remained a piece of property which hadn't been completely conveyed during the deceased's lifetime. Apparently, Haws sold this piece of property during his lifetime and was paid, but there was no deed conveyed. And so it was necessary to have a probate administrator appointed to sign a deed conveying the real property. And in the context of a probate, most of the real property can't be sold without court approval. So here's the petition asking for court approval to convey the deed to this person who had already purchased the property. And then there's a decree from the court authorizing the conveyance. In this case, you always have to have an order. So then there's a notice of the application for the decree. You'll notice there's a petition, a notice, a hearing, a notice, an order, a notice. Notice is required of almost every action that occurs in a probate case. Now, as you go back in time, if you go back a couple of hundred years, perhaps to the colonial era, you may find that the notices are not given in the file. That does not mean that they were not made. They were usually posted on the door or next to wherever the court was being held, in a courthouse or wherever else the judge was making his rulings. In addition to that, there was a proof of publication of the notice to the creditors of an estate. One of the benefits of having a probate estate for an estate was the fact that a notice could be issued to the creditors. This required the creditors to appear in the court and make their claims formally to the court, and unless they did so within the time period specified by the law in that particular jurisdiction, their claims would be barred, meaning they could not collect the debts against the estate unless they were made, the claims were made within the time limit. Here's the decree on the notice of creditors, stating that they had to file the notice or proof of publication of the notice. In this case, and more recently in time, notices are published in newspapers, usually a newspaper of general circulation within the county. That does not mean it needs to be the largest or most prominent newspaper. It simply means that a notice has to be published. In order to find, if you find these notices, then you know that a lot of information about the probate, and then can go find the probate file. So one method of finding a probate case and locating where those records may have been kept is by reading the newspapers that existed during the time when the deceased was passed away in that particular county. But you may end up having to search all of the newspapers published in that county. The next is a petition for an appointment. Now we're to the second probate action. In this case, the probate action was filed with some additional information, and this information becomes useful to the genealogical researcher. Here's an order appointing an administrator. This is the second one. This is the second administrator's bond, and whether or not a bond is needed is up to the judge. Here's the second set of letters of administration. You might notice that the documents have changed over the years, over the 33 years that this probate action was open in the Utah courts. The way of filing these documents changed from handwritten documents to pre-printed forms. They finally got to the end of the process and filed a notice of the petition of final accounting. The word final here does not really mean what you think it might. Final does not mean final. Final simply means is what the document's called. There could be many, many documents, and in fact, even if the probate is finally closed, it can be reopened for certain reasons, like finding additional property or whatever. Here's the final account and petition for distribution, and notice of the petition for final accounting. And this is the order for the hearing on the final accounting. So, you know, final is kind of a relative term here. It could go on for some considerable period of time before there is a final document. This is the case here in the Haws case, because here is a supplemental decree on distribution. In this case, they're asking for changes in the way that the final distribution is handled. This can possibly occur because in a case like this, where it stretched on for 33 years, it's not unusual that there would be substantial changes in the heirs. They may have remarried, they may have died. All sorts of things could have happened to the heirs during that long period of time. This is actually the last document, a final discharge of the administrator. But always, as I indicated, this may or may not be the end, and the question is, that's always a maybe. Thanks for watching, and watch for the next in this series of probates.